So what I thought I'd talk about is a bit about my experience with Network Rail, HS2, some light rail projects in the UK, and then maybe looking a little bit at the sort of supply chain side of things. So Network Rail. Network Rail is interesting because obviously Network Rail is one of the main employers in the country for big rail projects, particularly at Tier 1 level, and it's a very small industry, and therefore a lot of the contractors find it imperative to maintain their relationship with Network Rail. And I think that's what you can see in some of the processes that Network Rail and the contracting industry or community have put in place for the large rail projects and alliance agreements and frameworks that are in place. And I think it sort of started off with the Commercial Directors Forum, the CDF, which was set up about 14 or 15 years ago. It's a really interesting forum in which Network Rail and most of the commercial directors from the really top-level Tier 1 contractors and supply chain participate. And they meet, I think, a number of times each year. And they address commercial issues in the industry and discuss between them how they can resolve those issues. And one example of that was they agreed a fair payment charter 10, 15 years ago, which basically reduced payment terms from 56 days to 21 days for contracts with Network Rail. And it also got rid of retentions, cash retentions for Network Rail projects. And you know, when you think about the source of many disputes in construction engineering projects and rail projects, it's often payment. So the previous panel were talking about smash and grab adjudications and true value. That's all to do with payment. Obviously, if the contractor feels as though it's getting regular cash flow, that helps matters and presumably also helps to reduce the prevalence of disputes. They've also adopted the conflict avoidance process and also the dispute avoidance panel. The CAP process is something which is really established when a dispute has already arisen, and either party can refer a dispute to the panel to be decided. And it's decided pretty quickly. I think it's decided within 21 days. So it's a really quick process. And I think it works. The recommendations which the CAP panel provide are non-binding. If you're not satisfied with it, then you can proceed on further to other processes. But the CAP process, I think, has worked, as has also the dispute avoidance panel, or the DAP, which was brought in a few years after the CAP process. The dispute avoidance panel is more about avoidance rather than early intervention, and it's about establishing, and I got this from someone's comments on practical law, I don't think it was Matt or Jonathan, I think someone else did a note on this, which is talking about it effectively establishing a team to fire watch and to tackle and prevent a fire from taking hold when smouldering embers are identified. And I thought that was quite a good analogy. And in a way, for me, it's a bit like a dispute board in some respects. So I've had quite a bit of dispute board experience in my life, and standing dispute boards work quite well on the right types of projects, where you form a relationship, or the dispute board forms a relationship with the senior people within the employer and the contractor, or even the supply chain, and they discuss issues as they're arising on the project, and they have sites of issues that are coming up, and they can discuss those issues and maybe issue recommendations, or they can issue binding decisions. So I quite like the concept of DAPs, or dispute avoidance panels, and how those are obviously working with Network Rail. The other thing Network Rail does is it incorporates a suite of different clauses into the alliance agreements framework contracts, which are all about avoidance of issues or avoidance of disputes, and not adjudicating, not litigating, not arbitrating. And the idea really is to promote what they describe as a no-blame culture within the alliance or within the framework, bearing in mind a lot of these alliance agreements are for 5 or 10 years in duration. And if the parties do have an issue between themselves, the approach within the alliance agreements and the frameworks is to try and resolve that issue internally within the alliance. So not to refer it to an external adjudicator or to the courts or to arbitration. And it obviously works. You know, I'm involved in a number of big alliance agreements in the UK for different packages. Unfortunately, we never get instructed on any disputes. My work is almost wholly front end with helping them form the alliance and looking at the alliance documentation at the beginning and helping with advice during the project, but it's never been being instructed on a formal dispute process. And I thought it would be useful just to sort of read out the issue resolution principles as they're described, which are written into the contracts. And they say, or Network Rail say, these principles are to underpin how issues will be handled by the Alliance. And the first one is issues will be resolved in accordance with the Alliance principles, which is best for projects, effectively. Issues resolved at the lowest practical level within the Alliance. Issues are to be resolved quickly. Issues are to be resolved via an agreed escalation procedure, which covers people, authorities, issues, and resolution time. If they can't resolve the issues by discussion, then it's escalated up to the ALT, which is the Alliance Leadership Team, which is basically senior members of the contracting Alliance members and Network Rail. And if they still can't resolve those issues unanimously between themselves, then they can refer it to an expert panel, which is a form of expert determination. The expert panel will be standing, or should be standing, they should be appointed from the beginning, and they will issue binding decisions or binding determinations. And that's how Network Rail approach resolution of disputes, and that's how the Tier 1 contractors in the UK approach resolution of disputes. So what does Network Rail say about it? Well, interestingly, there was an interview given at a Seeker webinar a few years ago, and there's a gentleman called Michael Strickland, who was the head of Network Rail's Claims and Contracts Compliance team, and he reckoned that incorporating the CAP, the DAP, and also conflict avoidance pledge had saved Network Rail 2.5% of its £48 billion turnover. He said claims had virtually evaporated, and overall, with the collaborative approach and with the pledge in the background, they're seeing a dramatic drop in the number of claims and the number of outstanding disputes. I think that is really largely a reflection of the fact that it's quite a small community in rail and the need to maintain those relationships with Network Rail, which is why there has been a drop-off in claims. What else did I want to say? I also think it's to do with the nature of contracts that they have. So we have these Alliance contracts and frameworks, but a lot of the underlying construction contracts are target cost, which is obviously cost reimbursable, and I think that also helps avoid disputes to some extent. Having said that, I do have at least one dispute on my desk, which is for a Network Rail project in the north. And it's what I describe as a very old school dispute, where there are a number of disputed variations and design issues that have arisen during delivery of this particular project. And the engineer under the contract is just refusing to accept the possibility of there being any change or any variation arising out of the circumstances of the project. And I believe that this old school approach is really the engineer just trying to avoid signing anything over to the contractor at this stage so that they can have a final account wash up at the end of the project. And that, in my mind, is not how we should be working these days, but that's exactly what is happening on that Network Rail project.
Maybe he's a member of a Qatari royal family.
I hadn't thought about that. It's interesting. I shall investigate that after this session today. HS2, so moving on to HS2, I would say from the contracts I've seen for HS2 projects, it's a typical tiered dispute resolution provision. They don't incorporate any of the nice Network Rail fluffy approaches. It's adjudication or it's litigation. I have worked and am working on a number of different matters in HS2. I have to say personally, despite the fact that there is this traditional dispute resolution mechanism, I haven't really seen any real proper humdinger disputes on HS2 projects. And again, I wonder if, maybe just because I've just been working on the projects that are going well, but it may also be a factor of these target cost contracts, which are also being used a lot for HS2 projects. Of course, it's worth mentioning that there has been the public procurement wrangle, which I think the final decision was issued at the end of last year between Siemens and HS2 as to the procurement of the trains. Light rail projects. I'd forgotten about this project, but this is something I worked on about 15 years ago, if not longer. I wonder if anyone can guess which project it is. It's a tram project, and at the time, it was labelled as Hell on Wheels. Any guess?
Cambridge, is it?
Yes, and there was a Scottish accent there. Yeah, exactly. So there was a German contractor called Bilfinger Berger who don't do really any infrastructure projects these days. They were one of our clients, and we were working for them in the Middle East as it happened, but at the same time they were having their problems with Thai in Edinburgh on the Edinburgh Tram project. It really was, I think, a disaster of a project. And the gentleman who described the project as being hell on wheels, I won't be able to find his name now, but it's a guy called David McKay, and he was the chairman of Edinburgh Trams, and he described my client as a delinquent contractor who centred a victim. And he described the project as hell on wheels, and he quit his post about 6 months after giving that interview where he described my client as a delinquent contractor. About a year later, they had a mediation, and my client was paid nearly £70 million. So who was right there? Let's see. But what's interesting about that, I think, is mediation does work. But on that project, there was a long dispute before they got to mediation, and the public inquiry is quite interesting. I think they spent nearly £14 million on the public inquiry, which is more than they spent on the Chilcot inquiry for the Iraq War. It's the public inquiry document's quite illuminating revealing, because it talks about the lead up to mediation. It talks about the fact that there had been some adjudications beforehand, and arguably you could say you want to soften up your opponent before you have a mediation. And of course, there's nothing better than winning a couple of adjudications before you go into a mediation to try and get the leverage that you want there. But on that project, there had also been a radical change in senior management on the Edinburgh side, and I think that probably really helped unblock the matters. And one of the things they say in the inquiry report is post-mediation, the working relationship between the parties improved immensely. I think it was probably also to do with the contractor consortium having somebody in Edinburgh who understood construction projects from that point on. Two other things I wanted to mention: subcontractor supply chain disputes in rail. I think they're pretty traditional. I would say that they're adjudication type resolution processes these days. I don't see mediation being used a huge amount for these. It tends to be adjudications on payment disputes and variations. Crossrail. Occurred to me as I got off at Bond Street this morning. Crossrail, of course, why didn't I think about Crossrail when I was writing my notes a year ago? I don't really know, because I've had no involvement in the disputes in Crossrail, but there must have been a hell of a lot of disputes, you would have thought, in Crossrail, and it'd be interesting to know if anyone in the room knows about that. And I'm looking at Matt, who's nodding at me, and he may be able to talk a bit about Crossrail and perhaps CAP and how that may have been used at Crossrail to unblock some of the design or signalling issues. And to quote Matt's comments in his Practical Law blog, perhaps at the moment we're seeing a general shift in the market away from dispute resolution to dispute avoidance in rail projects. And I think that's seen by the conflict avoidance pledge, CAP and the DAP processes. And that is also, as Matt points out, embraced in the latest editions of the NEC and the FIDIC contracts, which talk about dispute avoidance measures being taken by the parties. And Jonathan, that's all I wanted to say.
Well, thank you very much indeed. Conflict avoidance seems to me to depend on good faith, which leads rather neatly into Mischa's contribution.
Thank you. Yes. For those of you who are here for the first panel, I did point out that I was junior counsel for the successful project company in the Lancashire schools case. And it's always interesting to hear other people's views of your own cases. So I was interested to learn that Luke Weigers thinks that Lancashire schools may herald the sort of start of a process in which courts overlook or override mandatory dispute resolution clauses, the kind of waterfall clauses that Luke mentioned in his talk. And this, I don't share Luke's views on that for the reasons that I'll explain. But it was something that I was hoping to talk about anyway, because we will all know one of the original rail disputes, if you like, was the case of the Channel Tunnel Group and Balfour Beatty Construction, which was a House of Lords case from the early 1990s. And in that case, the House of Lords held that the court had the inherent power to stay litigation brought in breach of an arbitration agreement. And there have been, since that case, a very long list of English and Commonwealth cases in which a court, faced with a party who has breached a mandatory dispute resolution clause by skipping straight to court proceedings, in which the courts have held that they should stay the claim so that the parties can comply with those provisions. And I don't wish to labour the point and to show why I think I'm right about this, but I have prepared references to 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13 such cases, the most recent of which are the decision in Open Operations UK Limited and Invesco Fund Managers Limited, followed by Children's Ark Partnerships and Kojima Construction, which was mentioned by the first panel. I mentioned those 13 cases to show not only do I think that perhaps Mr. Weigas's sort of hope maybe or fear that courts might override mandatory dispute resolution clauses it's not as likely to manifest itself, but also just to show you what an extraordinarily good job I did as junior counsel to persuade the High Court that notwithstanding this very long line of authority, they shouldn't stay in my case. So why then am I not? Do I not think that Lancashire Schools sort of sets this precedent that perhaps others do? Well, it's necessary to give you a bit of background to the case. It was a PFI dispute about some schools in Lancashire, and this particular phase was phase 2. There are 4 phases. It's been basically, when I was first instructed in this case, I was single. I've since met someone, married them, and had a child. So that gives you an idea of how long this has all been going on for. And I acted for the project company, which is, as you know, a special purpose vehicle under a PFI contract. And right up against limitation, we discovered a host of defects in these schools in Lancashire that we were managing. So we rushed in to get a claim against the building contractor Lend-Lease and the facilities management contractor Equans. We also, as part of this, joined the local authority to the proceedings. And we did that for the simple reason that we're effectively, as the special purpose vehicle, stuck in the middle between the parties. And what we didn't want to happen was to get a decision from the court that says you've alleged these defects, but they're not actually defects, so you're not going to get any money. But for the authority to say, well, we don't agree with that decision, we're not bound by it, and we're going to levy deductions against you under the project agreement. So we wanted to avoid that, so we stuck in the authority to just make sure they were bound by the decision. We didn't anticipate the authority would do anything. Unfortunately, the authority applied to strike us out on the basis that we hadn't complied with the mandatory adjudication clause in the contract. And there were several problems, I think, with that, practical problems which the judge very sensibly recognised. And the biggest one, to my mind, was this. If he was never going to strike us out, we weren't worried about that, but we were worried he might stay us. And if he did stay us, how would we then proceed to conduct an adjudication in circumstances where we were essentially saying the same thing as the authority, i.e. these schools are defective? We'd have to write down the line to Equans, the facilities management contractor, and to Lend-Lease, the building contractor, and say, we have to go through this process. Please give us your submissions. Please give us expert reports, and we'll just repeat them to the authority. So it's very difficult to see how that sort of adjudication process could work in these circumstances. But beyond that, I think the judge recognised that the only way that this case was going to settle was if everyone signed up to the same outcome. Because, as I said, Project Co, the special purpose vehicle, that were in the middle. So we had to make sure that any losses that were imposed on us by the authority, we could pass down the line to the building contractor and to the facilities management contractor. And if you forced everyone, or at least us, down the adjudication route, you would be moving away from that. So in that sense, I think perversely, it's almost an endorsement of an alternative dispute resolution process, because once the authority lost their application and realised, okay, we're in this process, that's when you can start to say, well, you can't get out of it now. Let's mediate and try to settle this and come up with a solution that everyone is happy with. So for those reasons, I don't quite think it's the end of the line. I will mention one other rail case that I thought was interesting, because I think it diverges slightly from the English position, and that's the Australian decision in a case called United Group Rail Services Limited and Rail Corporation of New South Wales from 2009. And that was a contract to design and build new rolling stock for New South Wales municipality. The multi-tiered dispute resolution clause in that case required the parties to meet and undertake genuine and good faith negotiation with a view to resolving the dispute. And that clause was held to be enforceable. Now, I have some difficulties with that, and I don't think it would be followed in England at the moment, for a couple of reasons. The first is that it's just an agreement to agree, and English law has historically been quite suspicious of agreements to agree. And the second reason is that it's very difficult to tell when you have complied with your obligation to meet and undertake genuine and good faith negotiations. By that I mean, at what point can you say, I've complied with that clause, I can now move on to the next tier in the dispute resolution clause, be that adjudication, arbitration, or what have you. So I think that case may not be followed in England, and certainly in the Lancashire Schools case, prior to adjudication, there was an obligation to consult between the parties, but it wasn't asserted by the authority that was an enforceable clause that we had to comply with before we could go straight to adjudication. The final warning I would give on this topic is that there was a hint in the Children's Ark case in the Court of Appeal that the position may be different where limitation is concerned. And I have the quotation here from Lord Justice Popplewell, and he said, if a party has commenced proceedings in breach of contract and a stay rather than strikeout will deprive the other party of a limitation defence, both those factors are important considerations in favour of striking out rather than staying the claim. So I think that where you have a mandatory multi-tiered dispute resolution clause and where you have an upcoming limitation deadline, you ought to be prudent and comply with the multi-tiered dispute resolution clause rather than going straight to court and assuming that you will get a stay from the court and then you can go back and comply with the multi-tiered dispute resolution clause. So for the lawyers in the room, that might involve building in an extra 28 or 42 days to conduct an adjudication, building that into the date in your calendar when limitation expires and you need to issue the claim form. So I hope that provides a bit more context to the Lancashire Schools case and gives you an indication as to how I see multi-tier dispute resolution clauses working.
Thank you very much indeed. Nigel, you've got 5 minutes to tell us about the mindset issues in Qatar.
5 minutes. Okay, well, I think studying ADR in different cultural contexts is essential because understanding the diverse approaches to conflict resolution, negotiation, and justice across cultures can enhance effectiveness. Cultural appreciation allows for a more nuanced and successful application of ADR in various settings, improving the likelihood of positive outcomes. We can look to the Nordics, the Middle East, and Oceania for examples of how unique cultural, legal, and historical backgrounds shape ADR practices. The Nordic countries emphasize a collaborative and consensus-based approach to ADR. Egalitarian principles and consensus are reflected on how disputes are approached, emphasizing mutual understanding and compromise. High social trust and strong welfare states influence their preference for mediation and conciliation over adversarial methods. For example, Norway's ombudsman system emphasizes mediation and informal resolution of disputes between citizens and public authorities, reflecting the cultural preference for consensus and cooperation. ADR is an integral part of resolving disputes, especially in family and labour law. For example, Sweden's Employment Protection Act mandates mediation in labour disputes before resorting to litigation, showcasing the integration of ADR into legal frameworks. The Nordics are also pioneers in integrating technology and innovative practices into ADR. Finland's online dispute resolution platform for consumer disputes is a good example, and it demonstrates the region's adoption of technology to streamline ADR processes and provide efficient, accessible solutions. Turning to the Middle East, it has a rich history of dispute resolution rooted in tribal and religious traditions. In many parts, there's a strong cultural preference for resolving disputes within community frameworks, often involving elders or community leaders, which aligns with the emphasis on honour and reputation. Traditional methods such as the sulha, which is reconciliation, and the shurha, consultation, are deeply embedded in the cultural and religious fabrics. In Palestine, the sulha involves community leaders mediating disputes to restore harmony and avoid lengthy litigation rooted in tribal and community-based traditions. The coexistence of formal legal systems and informal traditional practices creates a unique dynamic in ADR. For example, in Lebanon, civil and religious courts, Sharia courts for Muslim, canonical courts for Christians, may handle family disputes, reflecting the coexistence of formal and informal legal systems. Islamic principles often guide ADR processes, emphasizing restorative justice and community harmony. For example, in Saudi Arabia, ADR mechanisms often incorporate principles of Sharia law, such as the settlement of commercial disputes through Islamic arbitration centres, which emphasize justice and community welfare. The process is not just about resolving a dispute, but doing so in a morally and ethically acceptable way. International trade hubs like Dubai and Qatar are a growing intersection of international commercial law and traditional ADR practices. This fusion has led to the development of specialist arbitration centres that cater to both the regional and international business communities. Turning to Oceania, it has diverse approaches to ADR influenced by indigenous cultures and colonial histories. In places like Australia and New Zealand, there's an openness to informal and highly adaptive forms of ADR, reflecting a broader societal preference for practical problem solving. Indigenous dispute resolution methods, such as the Maori practices in New Zealand, are increasingly recognised and integrated into formal ADR systems. There is significant emphasis on inclusion and participatory approaches, where the indigenous Maori culture influences ADR practices. An example of that is the marae-based justice process. Community and village-based dispute resolution remains prevalent in the Pacific Islands too, often blending traditional practices with formal ADR processes. For example, or another example, is New Zealand's incorporation of Maori practice, such as the hui, which is a gathering for conflict resolution, into its family group conference system in juvenile justice, and it highlights integrating indigenous methods into formal processes. Traditional Maori dispute resolution methods, which are restorative rather than punitive, have been incorporated into the national legal system there, offering a unique blend of customary and formal dispute resolution methods. Colonial influences coexist with local customs and practice. So in Australia, the legal system combines the British common law with local practices, where mediation is commonly used in civil disputes, reflecting both colonial influences and modern adaptations. Australia's approach to ADR reflects its multicultural society and adaptations to accommodate different community needs, including specific strategies to address Aboriginal and Torres Strait Islanders disputes through culturally sensitive ADR practices. There is a strong emphasis on mediation and community-based dispute resolution, reflecting the communal nature of many of the region's population. In the Pacific Islands, community-based mediation is prevalent, with local leaders or elders facilitating the resolution of disputes, emphasising communal harmony and restorative justice over adversarial methods. Customary law often prevails, and ADR practices are deeply embedded with the traditional authority structures. Dispute resolution may involve elders and be conducted in a manner consistent with age-old practices that the community respects and follows. So, the effectiveness and acceptance of ADR depends significantly on how well the practices align with cultural norms and values. While modern Western styles of mediation and arbitration are gaining global traction, they are often adapted to fit local contexts, which can mean blending or modifying traditional practices. Understanding these differences is crucial for practitioners who operate internationally, and anyone involved in cross-cultural disputes, as it emphasises the importance of cultural competence along with technical and legal expertise in ADR. As ADR continues to evolve globally, there's a clear trend towards incorporating more culturally relevant practices into formal mechanisms. This hybrid approach is particularly evident in regions with strong cultural identities, where traditional practices are valued alongside modern legal frameworks. The future of ADR likely involves further customisation of dispute resolution methods to accommodate the diverse psychological and cultural needs of different populations, enhancing both the effectiveness and the acceptance of these methods worldwide. This is important because having meaningful exchanges is more urgent than ever. As the world becomes increasingly polarised, we struggle to hear and to be heard. However, if we can sit down together, truly listen, not just turn up and say that we'll listen, and express ourselves effectively, even if we can't resolve every disagreement, we can find ways to understand one another, to coexist, and hopefully to thrive.
Thank you, Nigel. There's a really interesting article in there. Thank you very much. But it's all good faith again, isn't it?
It is.
Matt.
Yeah.
2 minutes.
2
minutes.
That's great. That's great.
Your
I've
take
not
on this.
prepared anything, so 2 minutes should be just about it. I mean, it's interesting some of the points that are coming out. I think the multi-tiered sort of resolution sort of menu is very much in play. I think in metro projects, and I think that for me, if I think of the commonalities with what might work internationally and in the UK, where you've got this statutory stick of adjudication, I think the commonality is the behaviours and the desire to work with that partner in the future or not. And I think if you've got a one-off party and it's all about as much money you can get for this gig and then you move on to the next block, then I think you have a different set of contexts. That's why it's quite, I think if you look at the UK and the CAP and the sort of the Network Rail and Transport for London who took the lead, that works precisely because those people want to work with each other. something that Nigel said sort of sprung up an idea in terms of that we know what we know and we impose our systems on other people. The first time I did a conflict avoidance panel, as well as having to work out what it was, I went in very much as somebody who'd been schooled in adjudication and just ran it as an adjudication. That was a bit of a culture shock for the fact that there was an informality in terms of the communications to me from the parties. When I went to the meeting and I said, okay, present your case, it was, well, what do you mean our case? This is a project problem. And that required, I think, for me to have a sort of bit of a shift in the way I approach things. Now, more latterly, when I've done avoidance or CAP work, the first thing I do is say, well, we've got this 21-day procedure. Do you want a determinative procedure, or do you want something else? And I think that for me, it took me to realise that actually this can be sort of flexible. Now, certain situations, you need that answer. And again, in something where I've dealt with it, what I would call a fast track, a determinative process where I had power to deal with costs, and there was a sort of sequential, they wanted an answer, then they came back to me on costs. I then heard arguments of, well, they shouldn't get all their costs if you think they've won, because they unreasonably refused to mediate. And it got me to think about, well, was that unreasonable? Would it have resolved the issue? I concluded no. There was a Mexican standoff. You needed an answer. Adjudication or this fast-track process gave you that answer. Your grown-ups who said, we're going to comply with that even though it's only temporarily binding or a recommendation. And it worked. I did strip out some of the costs on and say, well, actually, potentially you didn't need to shoehorn this, and that took a bit of time, you spent some costs on it. But actually, this would have, and both parties in their cost submission said, we accept mediation would not have cracked this nut. However, it could have perhaps reduced things. And so I think for me, these models that are in the sort of the rail sector depend on that relationship between the parties and the ability of that person to come up with the right process. Or it might be that you need to get the right person to give you that non-binding recommendation, because I think there's perhaps I think it's almost like the Darwinian theory of arbitration or adjudication awards. The good survive and the bad ones die. There are certain people that parties will say, do you know what? I think that's likely to be the same result in a more expensive and long-winded process. Others, you go, well, you know what? One of the beauties of this being temporarily binding is it's totally bonkers, and we can go off and resolve it, or we can persuade somebody who the parties do respect to say, yeah, do you know, you got away with one there. So I think that's my sort of slightly more than 2 minutes, but my thoughts on my experiences and things in terms of metro and rail. So
well, thank you very much, Matt.